At 10:47 a.m. on the 15th of January 2026, President Donald Trump posted on his Truth Social platform a threat that reverberated through the halls of the Justice Department, the Pentagon, and major law schools across the country. If the corrupt politicians of Minnesota don't obey the law and stop the professional agitators and insurrectionists from attacking the patriots of ICE, who are only trying to do their job, I will institute the Insurrection Act, which many presidents have done before me, and quickly put an end to the travesty that is taking place in that once great state. The statement marked the latest escalation in a constitutional tension that experts in military and constitutional law consider unprecedented in American history. Unlike previous threats during protests or public safety crises, this situation presents a fundamental legal paradox. A president considering using military troops to suppress disturbances that critics argue were intensified by the very federal presence he deployed. It came after reports of incidents involving federal agents in Minneapolis, including allegations of lethal force, currently under investigation by state and federal authorities. This situation activates multiple constitutional tensions simultaneously. It questions the fundamental limits of presidential power during emergencies, places direct tension on the traditional separation between military and civilian authority, and creates direct conflict between federal and state prerogatives over public safety. As observed by Juliette Kayyem, former Assistant Secretary for Intergovernmental Affairs at the Department of Homeland Security, when I look at what makes American democracy unique, our constitutional structure that has a clear division between civilian authorities and military authorities. The timing is significant. 33 years have passed since the Insurrection Act was last invoked, the longest stretch of time since the act was instituted that it has not been used. To understand how we arrived at this constitutional crossroads, we need to trace the timeline of events. On the 20th of January 2025, Trump signed an executive order declaring a national emergency at the southern border, requiring the Secretaries of Defense and Homeland Security to submit a report within 90 days about whether to invoke the Insurrection Act. The April 2025 report recommended against invocation, but Trump continued considering the law. In June, during anti-deportation protests in Los Angeles, and again in October regarding Portland and Chicago, Trump floated invoking the act, despite governors' strong opposition. The situation escalated in December 2025, when the Trump administration deployed nearly 3,000 ICE and Border Patrol agents to Minnesota. Critics argue the approach was characterized by aggressive tactics that intensified local tensions. As January 2026 began, incidents between federal agents and civilians sparked protests. On January 17, Trump declared there was no reason right now to use the law, but maintained he would use it if people were being killed and courts were holding this up, or governors or mayors were holding us up. Understanding why legal scholars are so alarmed requires grasping how the Insurrection Act functions within America's constitutional framework. The law originates from the Militia Clause in Article 1 of the Constitution, which gives Congress power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. However, there is constitutional tension with the Domestic Violence Clause of Article 4, which says protection against domestic violence comes only on application from states. The Insurrection Act is actually a series of statutes that trace all the way back to 1792 that evolved significantly during the Civil War, when Abraham Lincoln used the act as legal basis to deploy U.S. troops without asking into Confederate states. The modern law has three paths for deployment: at state request, when unlawful obstructions make federal law enforcement impracticable, or to suppress insurrection that hinders execution of the laws. Critically, the Insurrection Act allows the president to override the Posse Comitatus Act, which stops U.S. military from performing civilian law enforcement. Historical precedents show why current circumstances are so unusual. The law was used during the Civil Rights era to assist with school integration, and last invoked in 1992 when President Bush responded to the Los Angeles riots after California's governor requested federal help. These uses followed a pattern. federal intervention to protect constitutional rights, or respond to state requests when civilian law enforcement was overwhelmed. What makes the current situation so concerning is how far it deviates from these historical patterns. Terms like insurrection, rebellion, and impracticable are loosely defined and give broad deference to the president, according to William Banks, professor emeritus at Syracuse. As Banks observes, it's incredibly open-ended and grants him a dramatic amount of discretion to federalize an incident. Most troubling, the Insurrection Act has also been rarely tested in the courts. Trump himself described the law as providing broad authority. Do you know that I could use that immediately and no judge can even challenge you on that? Joseph Nunn at the Brennan Center for Justice evaluates the situation as potential flagrant abuse of the Insurrection Act in a way that we've never seen because none of the criteria have been met. According to Nunn, what exactly is the insurrection? There is no insurrection. Are the insurrectionists the people of Minneapolis? Who exactly is being protected? Banks describes the situation as a historical outlier because the violence Trump wants to end is being created by the federal civilian officers he sent there. Legal scholars argue there's a constitutional doctrine involved. They can't intentionally create a crisis, then turn around to do a crackdown. Perhaps most significantly, scholars raise fundamental questions about presidential authority to send regular military to enforce laws domestically that have never been thoroughly vetted in the Supreme Court. The positions of key players reveal the depth of institutional tension. Minnesota Attorney General Keith Ellison declared he is prepared to challenge that action in court, while state investigators demonstrate capacity to handle the situation. Senator Richard Blumenthal expressed concern that Trump might use the Insurrection Act as a weapon to expand his deployments and turn these cities and states into armed camps. Within the administration, Homeland Security Secretary Kristi Noem affirmed Trump has constitutional authority, but reports suggest internal recommendations against invocation. The potential impacts extend far beyond Minnesota. Trump's approach is very unique because under no circumstances could you call the crime rate in our cities an insurrection, and represents wanting to use the military as an extension of law. Enforcement. Pentagon officials are reportedly nervous because they were raised not to go to war with us, with civilians. The Insurrection Act represents among the most powerful emergency powers at the disposal of a president, with few constraints and no role for Congress nor the courts in deciding what constitutes an obstruction or rebellion. Looking ahead, several scenarios could unfold. Trump could invoke the law, triggering immediate legal challenges that would force courts to address fundamental constitutional questions never fully examined by the Supreme Court. However, as Banks warns, challenges would face a tough argument to win because courts typically defer to the president on military decisions. Alternatively, Trump could escalate through other authorities, though previous court defeats show even alternative authorities face significant judicial skepticism. Congressional reform remains unlikely with Republican control, making legal challenges the primary check on presidential authority. States could attempt coordinated resistance, creating a federalism crisis. Most significantly, the Supreme Court could finally establish clear limits on presidential emergency powers or defer to executive authority while requiring procedural safeguards. This crisis tests whether our constitutional structure that has a clear division between civilian authorities and military authorities can withstand political polarization. The Brennan Center warns that the Insurrection Act is ripe for abuse without guardrails, and it can be used to undermine our democracy. Historical precedent shows emergency presidential powers often begin as temporary crisis responses, but become normalized precedents. Several indicators will signal Trump's intentions: additional federal deployments, Justice Department legal preparations, military leadership responses, and congressional reactions. American allies and adversaries are watching closely as the law's vague definitions leave significant room for presidential interpretation that could influence global perceptions of democratic governance. Legal scholars across the political spectrum are watching with unprecedented concern. The casual invocation of military domestic deployment authority, combined with vague legal standards and limited judicial precedent, creates conditions constitutional experts describe as uniquely challenging to democratic governance. How American democracy responds will likely determine whether emergency presidential powers remain constrained by constitutional principles or evolve into tools of political control, limited primarily by presidential restraint. This analysis is based on public statements, legal documents, and expert constitutional analysis. Some events cited remain under investigation by competent authorities. This analysis examines institutional risks and legal precedents to explain how the system functions when emergency powers enter tension with established democratic norms.